A very good evening and a warm welcome to the 108th IDG session. Today, we are honored with the kind presence of one of the illuminating minds of our country, Dr. Manoj Kumar Sinha ji, a repository of knowledge and wisdom in himself and an embodiment of humility and grit. So, I'm out of words when it comes to introducing you. Where to start and where to finish is the enigma I'm confronted with today, given your countless contributions to the legal fraternity and society at large. On behalf of IDG family, I, Aditi Singh, thank you for taking out time from your busy schedule and gracing us with your presence. The topic for today's session is status of right to health in India and globe amidst pandemic. I would request Shreya to give a brief introduction of our esteemed guest to the attendees.
Good evening, everyone. Welcome to the 108th Informal Discussion Group session. Today we have here with us a distinguished personality and an eminent scholar of international law, Professor Dr. Manoj Kumar Sinha. Being a member of the Informal Discussion Group, I feel privileged that I got this opportunity to introduce Professor Dr. Manoj Kumar Sinha, sir. Sir is the Director of Indian Law Institute and a professor presently on leave of NUJS. He did his doctorate in international law from Jawaharlal Nehru University, LLB from University of Delhi, and LLM from University of Nottingham. He has published extensively in the field of international law, international relations, constitutional law, international human rights, and refugee law in several reputed national and international law journals. In year 2004-05, he was offered the prestigious visiting professorship at Raoul Wallenberg Institute of Human Rights and Humanitarian Law. In the year 2007, Sir was elected as Secretary of Indian Law Teachers Congress and was re-elected in 2009, 2011 and 2013 for two subsequent terms. Sir regularly also delivers lecture at various educational and training institutes throughout India and abroad, including UGC Academic Staff College, training program of ICRC, training program of Ministry of External Affairs and Ministry of Environment and Forest. Sir has also authored, edited and co-edited numerous books, including Right to Health in Context of HIV/AIDS in India and Africa, Law of Sedition in India, and Freedom of Expression, Copyright Law in Digital World, Challenges and Opportunities, amongst others. So, we are very grateful that you graced us with your presence today. I now hand the floor over to moderator of today's session, Aditi, to take the session forward. Thank you.
Thank you so much, Shreya. In order to make most of the session, I sincerely request the audience to keep their microphones on mute and post their questions to Sir through the chat box. Now, I graciously invite Sir to address the attendees.
Thank you very much, Aditi. It's a great honor and privilege for me personally when I believe almost 20 days back I received a mail from Aditi and last year also a request was there, but I was not quite sure. I could not take a decision, should I go or not. But NUJS is always very close to me, and you all are some way associated with me. I always feel whenever some students come to the Indian Law Institute or any kind of assistance, that is always available to me. Whatever I am today also, I feel it's largely because of the students of the NUJS. When I joined in 2009, and a lot of subjects, lot of learning exercise I have done in the NUJS, like it started with the refugee law, international criminal law, business and human rights. All these papers I actually picked up because of the students' request, "Ki, sir, you teach something." Then I said, okay, let me pick. And I started learning in that process because the students always, it was interesting and it was also challenging to teach. And I remember when I started with the, I'll take 1 or 2 minutes, then I'll quickly come to the subject. But it's an emotional association, so I don't want to take much of your time on that one, but still I feel. So I started teaching one paper on the international criminal law. Very first year, Professor M. Singh asked me, and that was direct teaching exercise. Prior to that, I was in a research institute. Not so much active teaching, I had occasional teaching. So he said, no, students are very tough. So you start with a small group. You start an elective paper. I started with international criminal law first year 25 students joined, and then after next year another 70, 80, and I have a problem not to say no. So I don't know how to say no. So then it, like, third year it went to 180 students, I think, and then I used to go to the third floor in a big room, and that time mic was not good, everything is like, but still we managed 180 students, and then subsequently I reduced. So I feel very, whenever I visit campus, I try to see that I get a chance to interact. But it's because always you all are in the classes, so I meet VC sir and other colleagues and come back. But it's very good that you thought about me and you gave me an opportunity to share some of my ideas, some of my thought on the topic, which we never considered so important. When we talk about the human rights, when we talk about the fundamental rights, we focus on the part third. We never consider social rights very important. So right to health is a social human rights in that way. The moment you make it a social human rights, it's an entitlement, and then progressive implementation and other things are there. So it's become little bit like, complicated. It never attracted huge attention of academic also. But I believe that this day, like, now onwards, people will start working on the particularly part 4 of the constitution, and also on the various international human rights instruments. Well, I have structured my talk in 30 minutes, as Aditi has told me. So I just try to focus on 30 minutes. I'll not take much time on that count. What I'll do primarily, I'll focus on the started with the definition of the right to health, which you know, but quickly I'll go. And then the typology of obligations at the international level. And quickly we come to the Indian scenario also, and then floor will be open for the question answer. So when we start with the right to health, so we look into the first definition we find under the WHO Constitution, World Health Organization Constitution, which was adopted in 1946. So that recognized the first time we find right to health has been recognized. Of course, the World Health Constitution should have that. And it says the enjoyment of the highest attainable standard of health is one of the fundamental rights of human being. One of the fundamental. So like enjoyment of all human rights are linked with the right to health. Like, right to health is like, it cannot be isolated. You can't keep it in a separate bag. So right to health is also linked with the right to life. When you look into the jurisprudence, some of the jurisprudence in the European Court of Human Rights, European Court of Justice also, where people have stressed right to health to the right to life, they started linking with the right to life. So somewhere right to health is also linked with, which court has in Indian judiciary has done, which we look into that. So the definition is like, it's a linking with the human rights in the very beginning in the WHO Constitution. And it also defines health as a state of complete physical, mental, and social being, and not merely the absence of disease or infirmity. So the moment we say, okay, we have no disease, so we are fine. So right is like, complete. It's more holistic. It talks about the physical, mental, and social being of the human being right to it. I mean, it's a larger. Its ambit is quite bigger in compared to that. Immediately we look into that after 1946, we move and we see that Universal Declaration of Human Rights in 1948 under Article 25 also speaks about the right to health. But most important, when international context we look into, we go to the article International Covenant on Economic, Social and Cultural Rights. As I say, this is social human rights, so it has become part of the International Covenant on Economic, Social and Cultural Rights. And there are two articles which are very important in our discussion today, that is Article 2 and Article 12 of the International Covenant on Economic, Social and Cultural Rights. When I talk about the Article 2 talks about the state's obligation. When we talk about, so like, government of India has to be linked with that particular obligation, state obligation, which we'll try to see. And Article 2 again defines what right to health means. So you hear me? Sorry.
Yes, sir, clearly.
I hope that you heard about the WHO definition in Universal Declaration of Human Rights, and subsequently the main instrument what we have today in the international level, that is the International Covenant on Economic, Social and Cultural Rights. And particularly two important provisions will follow, we'll discuss, that is Article 2 and Article 12 of the International Covenant on Economic, Social and Cultural Rights. So Article 12 basically talks about the right to health. We don't need to go into again definition, but I'll leave it there. Article 2 is the but to understand the Article 12, we have to go back to the Article 2, which talks about the state's obligation. And state's obligation, when we talk about the state obligation, it's primarily we have to see what kind of typology of obligations we have under the international human rights. So under the international human rights, with a special reference to the International Covenant on Economic, Social and Cultural Rights, what we see, it has tripartite obligation. There are 3 types of broad obligation it talks about. What tripartite obligation, what I mean, there's is obligation to protect, one, obligation to respect, and obligation to fulfill. So I'll define one by one that obligation to protect, obligation to respect, and obligation to fulfill. So what obligation to respect implies? What obligations to respect? What obligation to respect applies? It says obligation to respect required states to abstain from doing anything. So it puts an obligation, so like a non-interference. So like it says obligation to respect requires states to abstain from doing anything that violates the integrity of individual or encroaches upon their freedom. So some way it's a, you keep a distance. The state should respect the individual rights. When we look into if we go to the social contract theory, particularly with the law, which says right to life, right to property, right to personal liberty are very much inherent to the human being. It doesn't require. Rest of the things we have given power to the state. Even if you look into the John Rawls in the his book in the theory of justice, so he talks equal liberty. That is the first fundamental principles he talks about. So even political philosophers or legal philosophers, they spoke about the importance. So they say so obligations, so states should not interfere. And we have understood right to health is also very much linked with the right to life. Then we go to the another is the obligation to protect. Obligation to protect implies it obliges the state to take all necessary measures to prevent others from the violating individual's integrity, dignity, and well-being of other human beings. So sometimes, I'll just take 1 second. Sorry, I switched off fan. So that obligation to protect. So state has a responsibility. Who will protect our rights? State has a responsibility and that is the reason when we enlarge the scope of protection, we have thought about the state has also obligation to protect our fundamental rights from the third parties, from the multinational companies, transnational companies. So when they try to link business and human rights, they use this particular doctrine in that particular aspect. So obligation to respect, you have understood, obligation to protect, and of course the last is the obligation to fulfill. Obligation to fulfill requires states to take all measures progressively. That is the main important problem comes into when we talk about the economic, social and cultural rights. Take all necessary measures to ensure that each person within their jurisdiction opportunity to obtain. So whatever the needs, so progressive implementation. So these are the 3 broad obligation, typology of obligations under the Article 2 of the International Covenant on Economic, Social and Cultural Rights we find out. And we see that when we read the Article 2 paragraph 1 in detail, it talks about the progressive realization. I will not take because limited time. A progressive realization. State has to take steps for the implementation all appropriate measures. So broadly, 3 terms we can cull out from reading of the Article 2. So how this right will be applied? Progressive realization, because it's in the context of economic, social and cultural rights. So it talks about the progressive realization. Progressive realization, what it means is it acknowledges the constraint due to limit its available resources. So it talks about, so a state maybe policies, program and lot of things. So gradually these rights will be implemented. It cannot be implemented in a one go. That is the major thing. And the second, it takes about the steps. States have to, so state has to take appropriate steps for the implementation of this particular rights which are mentioned under the convention or covenant, it's mentioned. But what the steps? That steps should be deliberate, concrete, and targeted. It cannot say it's a long time you are taking. So, like, no, it's a very calculated, targeted step which we have to take, and all appropriate measures. That measures can be legislation, that can, measures can be judicial guarantees, and other things are there. So we close that one. Because of the time, I'm not going in much detail, but we have called out the important aspects of the international. So state has, so we have understood the international human rights normative framework, particularly when discussing or applying the economic, social, and cultural rights. It allows a state some kind of leverage to go, like, gradually to implement. And also important point, when you read Article 2, which talks about states, like, individually and collectively also, it can seek assistance for implementation of economic, social, and cultural rights. State can seek collaboration and cooperation from international institutions and other states. So that is very important in that particular. So I finished with one part, WHO definition, UDHR Article 25, I just referred, and Article 12 of the International Covenant on Economic, Social, and Cultural Rights. When this crisis started, this pandemic, like, in the beginning of 2000, end of the 2019, from the Wuhan, and then we see that gradually it entered in the number of countries, pandemics. The first thing it occurred to me as a, as a scholar, as a student of law, I started thinking about whether this problem, so like what is happening at the present, we all are concerned individually. And what is happening, and that leads to the criticism which WHO has also come, vaccine nationalism, health isolationism. So they say nationalism, if you talk about the vaccine national, so US government has said we are going to take care of our own people. UK government has called, we have first will try to administer the vaccine as early as possible to our own citizen. India has initially helped the other countries. Now we are also almost focusing on that. Whether this vaccine nationalism will help to us to stop this pandemic, because it's a global, this problem is global, it requires a global solution, and we have to, all nations have to think about the other nations, like African countries, where only 1% people have been vaccinated, even less than 1% till date. It's like, if culture of vaccine nationalism continues, it defeats the purpose of the United Nations Charter, and that is the Article 1, Paragraph 3 of the UN Charter. So it defeats the entire Article 1, Paragraph 3 of the United Nations Charter. What Article 1, Paragraph 3 talks about? It talks about to achieve international cooperation. It, like, just one line I'll take, to achieve international cooperation in solving international problems of economic, social, cultural, or humanitarian character. So this problem is having humanitarian character, and it speaks about, so one of the purposes of the United Nations is international cooperation to resolve is this kind of crisis. So we all have to work collectively. So what vaccine nationalism, luckily, fortunately, government of India or South Africa and other countries, they have requested for the patent issue, waiver of the patent, or saying that if you apply compulsory licensing, it's a domestic affair. It doesn't help the patent waiver, licensing, and other aspects, and things are moving positively. WHO, WIPO, and WTO, all three organizations are working in that particular direction. So we see that. So collective, it's a huge problem, and it has to be resolved collectively, where it all has to be worked. If I last point at the international perspective, and then I'll quickly come to the Indian perspective, keeping in the time in the mind, what I see when I took the four important, when you say status of right to health in India, if I evaluate, so status of the right to health in India can be examined, can be understood, can be assessed by examining the four important elements which is required to fulfill or apply the right to health if a country has. So what are the important elements? I am just talking about the first, about the availability, which means
functioning public health and healthcare facilities. Functioning public health, whether we have sufficient number of functioning public health and healthcare facilities, goods and services, and other things related with the health issues. So availability is important. Availability one. Then second is accessibility. Once you have available, so accessibility is another important aspect. So these facilities or services are accessible to everyone. Accessible to everyone without discrimination. Without discrimination. So it's like, if only a religious group has started health facilities and say, only these sections of the society. So accessibility also become very important, whether the facilities are accessible to everyone, adhering to principle of non-discrimination. When we talk about the accessibility, accessibility has again 4 important components. Accessibility has 4 important components. And what one component I just said, non-discrimination. One important component is non-discrimination. Second component, which is very relevant, physical accessibility. So when we talk about the physical accessibility, it takes us to the first element, that is availability. Accessibility means like, if you have to walk 100 kilometers to get the medical treatment, that is not available. Accessibility means physical safe distance, means 10 kilometers, 20 kilometers, that will be sufficient. But when you talk, you have to walk like 100, or you have to travel 200 kilometers, that is not available, neither available nor accessible. Third, which is very important in country like India, is the economic accessibility. The medical facilities has to be like, economic accessibility. What it means, it applies to the affordable. So whether each sections of the society can avail the medical facilities, particularly the government or whatever. And last component in this one is the information accessibility. So we have also rights. So you as a law students, you have a right to understand, seek the information from the government, seek and impart information. Of course, like information, what kind of progress we are making towards the vaccine and other things, we can always examine it. But we don't have a right to seek a private information. If a private person has been admitted and say, I have a right to information accessibility, confidentiality will come and privacy will come. There you don't have a right, but you have a right to seek the information from the government regarding what are the plan, how you are going to take, which government also every day comes on the television and disclose what are the steps they are taking. And the last 2 points, which is like, acceptability means all religious group, diversity takes care, and quality. I'll not go into quality, means whatever the medical facilities should be, it's a better quality. That is very important. Quickly come to the Indian scenario, and then we'll open for the floor, will be open for the questions. So I just, first part which I have said, and so as a student and as a scholar, you have to think these are the important points. When we talk about the typology of obligation, you don't need to go much detail about you can examine, you can critically evaluate, looking into the important elements, availability, accessibility, acceptability, and quality, and then you say where we stand, whether the status of right to health is sufficient. No doubt, when we talk about the Indian scenario, Indian constitution or something, we see that right to health is like, it's a subject which primarily falls into the state domain, in the federal structure, which is there. So entry 6 of the list 2. So entry 6 list 2, which makes this as a public health, sanitation, hospitals and dispensaries, it comes in the second list under the Article 256, 7th schedule, entry 6, list 2, it talks about the health. So health is the state subject in there. Of course, the national government or union government has also role to play under the entry 29 of the particularly for the prevention of the extension from the infectious disease or pandemic kind of situation, entry 29 of the list 3. There's another important list which we hardly talk, that is the schedule 11. Schedule 11, entry 30 and entry 23. What schedule 11? Schedule 11 is related with the Article 243G of the Panchayati Raj and the municipalities. So if you look into the schedule 11, entry 23, it talks about the panchayat and the municipalities have also right for the right to health. There you can say health facilities, another thing. So we have 3 places we look into this. It is divided in the Indian scenario, but in this pandemic crisis, all the time has come. We work as a cooperative federalism. Work in the in a one nation, one treatment, and that is the way we have to go into. Court in Indian court in a series of cases has recognized what? Right to health and life is a recognized integral part of the right to life. So court in a series of cases, and they say that under the Indian constitution also, right to healthy life is recognized as integral part of the right to life. The constitution, when we look into the constitution, you have number of articles are there, particularly 39E, F, then 47, most important, the 47, 48 also we can take, 51G we can take, which are related with the environment. So those students who have worked in the environment, you find the environmental laws also help in the right to development angle has been, right to health angle has been taken when court has decided in number of cases. Most important cases which I consider in today's time, which takes me any discussion when we talk about the fundamental rights or other rights, any discussion remains incomplete if we fail to identify the great contribution of Justice Krishna Iyer. So we should start with the Krishna Iyer, which he had said long time back in 1980 in deciding Ratlam municipality versus Bardhichand case. There Justice Krishna Iyer observed, the state will realize that Article 47 makes it paramount principle of governance that steps are taken for the improvement of public health as amongst its primary duties. So Article 47, it talks about the right to health, state's duty. I'll take Sarabjit and other questions later. So the questions are coming. So just wait for some time. Then one by one we'll do that. So we see that Justice Krishna Iyer has realized the importance, and subsequently series of cases. We don't need to go on all these cases, but consumer education, Premanand Katara, Paschim Bang Khet Mazdoor case, then Vincent Pengulanga case, and Rakesh Chandra Narayan, and recent case also where Supreme Court has taken. There are a couple of cases are there, but I'll focus only on one case because paucity of time. We'll go to the Paschim Bang Khet Mazdoor. Paschim Bang Khet Mazdoor, which was this, it's a case 1996 for SCC 37. That is the pay case, citation. So in that case, court had said, the Supreme Court of India, that the government, and that is very relevant, is that if had we followed the Paschim Bang observation by the Supreme Court of India in the case of Paschim Bang Khet Mazdoor, in some extent, we could have effectively handled our situation. We have to make a distinction. We should not, what is happened in the last 2 years, if suppose we develop this kind of infrastructure, always this infrastructure will remain empty. It's an extraordinary situation. So our failure is to deal with the extraordinary situation. But time has come to also examine whether we have institution or infrastructure to deal in ordinary time. It's like extraordinary time, ordinary time, whether we have sufficient number of health facilities to tackle the crisis in ordinary situation, not in extraordinary situation. So we are going through the extraordinary situation. So what court has said, that is very important. We'll quickly examine. And court has said in this case, the court held the government hospitals, that government hospitals run by the state and the medical officers employed therein are duty bound to extend medical assistance for preserving human life. So they say that medical officers, they have an obligation, duty bound, to extend medical assistance for preserving human life. Failure on the part of a government hospital to provide timely medical assistance to a person in need of such treatment results in violation of the right to life guaranteed under Article 21 of the Constitution. The further court says, court also held that primary health care center be equipped to deal with medical emergencies. Like a medical emergency was not attended in this particular situation. And last point, which is very important, no state, there is no justification. You can't say we have no fund. So what the last point is very important. It says it has also been held in this judgment that the lack of financial resources cannot be a reason for the state to shy away from its constitutional obligation. So like you can't make a justification if we don't have any resources or something, and that is the reason we are unable to take care of the health facilities. Despite a long list of cases which I have mentioned, some of the cases I have mentioned, and there are many you may add also, there is no problem. But and it has been very strongly recognized that right to health is linked with the right to life. So that discussion is settled. There is no need of further going. But what we have seen, it's become more an academic exercise. When I come here or you go somewhere, we discuss case and refer. When it comes to the implementation, we see a major problem is there. And that is the reason also the Supreme Court of India in June 2020, on 12th June 2020, took a suo moto case, and also later on the vaccination issue, like Justice Chandrachud also addressed. So we see the suo moto court has taken again in the case of the treatment of COVID-19 patients and dignified handling of dead bodies in the hospital. So that has become another case in the latest in 2020, June 22, which is going on in by the Supreme Court of India. So what we see, court keeps on repeating. There's a court, every time court has to come and again say same thing what has been said. There is some kind of deficit or on gap on part of the executive, on the part of the government to taking the health facilities very seriously, which needs to be addressed. When we talk about the any aspects with fundamental rights and directive principles, we always focus on the part of Supreme Court jurisprudence. But sometimes some judgments from the high courts are also landmarks. So as a scholar, you have to look into the high court judgment also. And particularly some of the courts are very progressive in that particular context, like Delhi High Court, Kerala High Court, Madras High Court. These are the Mumbai High Court. Some of the high courts are very progressive and very important. So as a scholar is there. So one important case, which I had no idea. I came to know because I read, because you people asked me to work. So I started reading and I read an article by very good scholar, Arun. He is right now in Azim Premji. So he wrote a paper and then I started reading on that paper, and he highlighted one case whether this is a core rights, right to health is a core rights or not. And that he located in the judgment of Delhi High Court, which is popularly known as orphan drug case, or it's between the Muhammad Ahmad versus Union of India, 2014 single bench judgment. Justice Manmohan, he decided that case, one single bench, and extensively international law, some of the part which I have discussed, he discussed in the case. And I believe this is the contribution of some of young interns. So young interns, because general comments, 14, Article 2, lot of international input, which I believe is largely by the interns who works under the judges. They supply these are the information and other things, because there is a sea judge change I see personally, and I believe that is a contribution of the students. No judge, traditional judge can go, which teachers are unable to locate. So the judgment, but full of international judgment is there. Even South African court judgment is there. But finally, he says in the approach, he broke new ground, and that he says core obligations under the right to health are non-derogable. It says core obligations under the right to health are non-derogable. So it says non-derogable means no negotiation. It's very fundamental, which we have to respect, which we have to fulfill all the time. And it says at least minimum minimum efforts should be taken to respect the right to health. So that particular case is very important, which refers about the core rights. It's a non-derogable rights, which cannot be suspended. It's irreducible core rights. It's very fundamental, you can also say, in the judicial. So I feel, I'll not take much time. These are the ideas which I wanted to share. And I feel personally that vaccination part which has going on in the pandemic, this is the only uh, solution which we have, how we get vaccinated twice in our in a 1 year time, and then we see. So vaccination become very important, and vaccination has to be seen in the global perspective. It cannot be in isolated. So if nationwide, then there is a danger of what I said, which WHO said, it's not my word, is vaccine nationalism or health isolationism is not appropriate in this particular crisis. I believe that we have to walk long distance in Indian context, particularly implementing right to health, because we don't have sufficient number of the health facilities. We don't have the medical personnel, sufficient number of the medical personnel. I'm not saying that, I'm not blaming the government for the extraordinary situation. Even for the ordinary situation, those of students, many students from our university also stay in far away places. They feel the real problem where there is if you are in big cities, you have all the facilities. Even big cities encountered big challenges this time. But in small cities, you can imagine what kind of situation might have prevailed to deal with the pandemic. So we have to revisit, we have to look. Government has to again examine, not the judgment. Now time has come to develop the institution. If social institutions are not effective, that needs to be reformed, modified, or abolished. So social institution, if it's created properly, then rights will be protected. With this, I end here, and I think I have taken 40 minutes. So, all right, thank you. Over to you, Kriti.
Thank you so much, sir, for your enlightening words. With due permission, we would like to move on to a question answer session. I would request all the attendees to start posting their questions in the chat box.
There are many.
So the first question is asked to you by Sayam Jha. So, post the internet boom and increase in affordable internet access, do you think under the accessibility aspect of right to health, online accessibility should also play an important role to increase the reach of quality medical consultation and guidance to further off regions of the nation?
I think, in some extent, the increase of the internet facilities and availability to a large number of people, and we have seen, so because the treatment also has been, if you are in the mild form where a consultation with a doctor, medicine about the prescription of the medicine, it has been used in this particular crisis. In isolation, in home isolation, there is a proctor site also. There are a number of sites where doctors are there available, so consultation is there. Some way, you don't need to go to the hospitals for the, if a disease can be cured at the home, internet has served that particular purpose, and it has been used effectively. A large number of people, 90% people, they were treated in home, including us also, using internet facilities where doctor is there, available is there. So some way availability aspects can be addressed, but physical infrastructure, when admission is important, when survival, you have to be there, then hospital is there. It will supplement, it will definitely strengthen the, or it will reduce the dependence in some extent where non-admission is concerned. If admission is concerned, then hospital is required, but it helps. No doubt it helps, and I think it's going to stay.
Thank you so much, sir. Next question is asked to you by Subhajit Chaudhary. How can states, especially the likes of India, which has an insatiable population and limited resources, supposed to balance such rights vis-a-vis the extreme crunch of resources? Does the state have discretion to decide for whom it wants to ensure the right to health under Article 21 of the Constitution, or do all citizens have equal claim to this right in the ongoing crisis?
Of course, all citizens, state cannot discriminate. So all citizens have equal rights, equal claim for the right to health. I agree with you. And but today allocation is we have to see how much percentage we are allocating for the health or the education sector. So when we look into those sectors, we find we have capability. The resources is not a big issue in India. Even today, after the new health minister has come, he has huge money has spent. And even if in case to deal with some of polio eradication. So polio eradication started when some of you might have not born. It started in 1994, I remember, with the World Health Organization program supported by, and then that's continued for till date. So there are, you get for the implementation of certain rights, economic, social and cultural rights, we can also depend on the support of the international institutions. And that is why some of the scholars who believes in the cosmopolitanism, they argue for the global basic structure. They say it's global basic structure. So there is a, like, human beings are not confined to a territory. Humans being are the citizens of the world. So there is there. Of course, that those are the philosophy. I don't want to go into that, but I believe that resources is major challenge. But now after 70 years, the time has come to see that where we are standing, and the facilities have to be created for everyone. It cannot be a special sections of the society, and it has to be affordable. We have to focus on the inclusive health facilities, not the exclusive health facilities which is private sector. If you privatization you are doing, then I can understand a large sections of the society will never ever covered, and they will always look for the health. So the time has come to strengthen the government public health facilities. And for that, whatever resources is sufficient, I believe, Sobaji, willingness is required on the part of the government.
Thank you so much, sir. We have Anirudh with us. He would like to ask you a question himself.
Yeah.
Thank you, sir, for your very important lecture on right to healthcare. So recently, we witnessed that there was some debate in the country when we see certain institutions of the government, they endorse traditional forms of medicine, let's say Ayurveda or homeopathy, and then modern medical scientists are opposed to such suggestions coming from the government. So when the state itself is promoting certain forms of healthcare, then what are the international standards or international norms that can bring a common consensus as to what constitutes appropriate medical care and what does not?
I think, like, if I take the all forms of medical, Ayurvedic, Unani, Ayush, and then of course like the allopathic, which is common, which is there. So globally, more allopathic treatment, you go to doctor and medical, like prescription is there. But in India, the traditional medicines are always there. Like, for many way, 30, 40 years back, some of the ailments were treated at home, haldi, chuna, whatever, like, combination that is very much there. And that is very our indigenous, cultural, and it's a integral part of our life for the cough and cold. A number of diseases always cured with the traditional healing medicine. So we have grown up in this kind of culture, but certain diseases which requires immediately. And the focus, subsequently government, like, government initially focused on that particular part, but today we see a large number of focus on the Ayush and other kind of alternative medicines also become a priority area for the government. Government has started giving on that particular. I don't want to go on that debate, which you might have witnessed, and it has created a lot of issues. It's a faith. But like, allopathic gives you some kind of, even given a chance, I'll go to the allopathic treatment first. I will not rely heavily on the traditional medicine or like, Ayurvedic medicine. I take that one as like a supplement, which can be, may not ignore, I may take. But for me, in the some way, allopathic, which is more universally accepted. So universally accepted, so government should give the priority to that. Let the people decide. They can opt for the both. If they cured by the alternative medicine, Ayurvedic medicine, they don't need to go to the hospital. If they don't, they will definitely go to the allopathic doctors or hospitals there. But the state should focus on, I personally believe, on the medical center, means allopathic treatment. The priority should be there. And if you can, if after like 3 districts, 4 districts, you can create an alternative medicine, Ayurvedic hospital, homeopathic hospital, doctors are there. You can do that one place, but that should not take space of the allopathic. That has to be the universal, acceptable, and which has to be continued in India also. And you see that private hospitals, a huge number they have come. Why they are so successful? They are not treating Indians only, they are treating outside people also. People are coming from there because there is a belief. and people are paying a huge amount of money. Insurance culture has developed in India. People are taking medical insurance. If like when it's a cheaper, because you want to secure your health. You don't know whether health medical facilities in the government hospital you will get it. So your papa and mummy has taken care that all family members are secured. In time of emergency, they will be admitted. It's not for the Ayurvedic treatment. It's for the allopathic treatment. So subconsciously also, we all are working. We are privately, we are taking medical insurance. In the government or employee also get the government hospital treatment and all this. So it's become, it's a optional kind of treatment is there. So focus is there. Choice also preferred by the individuals more on the allopathic treatment. Arvind, Anirudh is fine, or you want to add something?
No, sir. I understand your way, and I completely agree with it as well.
So my only submission is the state should not dilute. That the first, like when you have to draft, you say ki allopathic will be the first, thousands hospital. You don't see that 800 Ayurvedic and 720 hospitals is there. Then the problem will be there. So first, if I have to give a priority, I'll give the priority on the allopathic medical centers, where qualified medical who have studied in the medical colleges. Those persons should be increased. Their numbers should be increased. Medical colleges should be increased. Medical hospitals should be increased. And of course, you want alternative. I have no objection. I have all due respect for that system also to exist. They can coexist peacefully.
Thank you, sir. Next question is sent to us by Srijaya Singh. Sir, you have also been a part of multiple organizations that concern legal education. What are your thoughts on allowing law teachers to practice law in courts? And as a follow-up question, even though right to health has been recognized under Article 21 in multiple judgments, it is not accessible to many sections of society due to health inequities. But these were efforts made by the judiciary. Do you believe that we need the legislator to enact the same as constitutional amendments so that this right can be meaningfully recognized?
There is a lot of suggestions also. To start with the second question, and I'll come with the law teachers practicing. About that, I'll come later. Suggestions are there. Scholars have expressed, number of individuals have expressed, students also expressed. Why not we have 86th constitutional amendment? Why not we go Mohini Jain and Uni Krishnan case and then 86th constitutional amendment and make it a fundamental Article 21A, which talks about the right to education. Similarly, we can exercise, because it may address, because at present, despite a series of judgments, multiple judgments of the Supreme Court, inequalities are very much available, common, visible, that cannot be denied. And it has not served the purpose. I have also said, and honorable courts have also realized. Why court has to say every time? I can say and you can ask. The right to health is the Article 21. It's a link with the fundamental rights. Why court is repeating every time? Courts have simply said, we have said same thing in 1996. Why you are coming? You go and government should take implement. Why court again examine same thing and conclude there are something right to health is a human right? Why Delhi High Court has to speak about? But Delhi High Court has also taken opportunity to expand by putting some kind of international, some kind here and there. So they make it more attractive judgment in that particular count. So whether government, of course government can, I believe that government should adopt a legislation, not for the amendment. Even the right to education is there as a fundamental rights. And there are a number of reasons. If I say, with all due respect to all of you, a large number of bright students cannot join in a law schools, many law schools, because of the time of the prospectus. Even 5,000 rupees, 4,000 rupees becomes a big issue. And you feel very bad. I have come across with the Delhi University student. He came to me and said, I said, you should have applied for the CLAT, and said, so 5,000 rupees. So there are challenges. So what we are talking about, where a large number, if you go and you find there are parents, there may be many students who have qualified the examination, could not take admission because of the lack of fund. Many students might have joined 1 or 2 years left because of the country. Many are now facing in school or colleges because their parents are no more. All of a sudden, it might have happened in the it happened in the school or colleges. So now it's a very both parents have gone all of a sudden because of the COVID-19, and family pressure is there for the young boy and girl if they survive. So the situation, state support is negligent some way institution support is there. So that kind of problem is there. And health facilities, what we have said, of course we have to have a good health facilities the way in the now I'll say in the Nordic countries. I'll not say in the European countries. If you are in Sweden and if you are in Norway and other, you pay only 70 to 80,000 rupees in a year, and you can go for anything, many times heart surgery, whatever you want, that care can be taken. But the treatment has become expensive in the United States of America, United Kingdom also. Health services have become very expensive. But we should not think about that, but we have to have address that what I have said: availability, economic affordability, accessibility. When I say that one of the component, the medical facilities must be affordable, where everyone can go, and then they have a choice if they want to go to the AIMS or they want to go to the Max Hospital in Delhi. It's perfectly fine. That's a personal choice. AIMS also very qualified. So always you see in the AIMS, only poor people are lining. I go AIMS, I see that public facility, doctors are equally brave. Only thing, you have a huge rush. So if you have patience to stand in the queue for some time, then you get a free treatment in the All India Institute of Medical Sciences that is there on your doorstep. If you wait for the operation for 2 years, if it's not emergency, you get the free treatment. But if you don't have time or for any reason, then you have to go the private. So at least that kind of AIMS, now we have many AIMS. I hope that it works like the way it works in Delhi. Now, second question is very interesting. I think you have taken the cause on behalf of the law teachers to whether they should practice or not practice. Law teachers were practicing for many years, particularly in Delhi University. And whether it was because Bar Council was not ruled 90, 91, 92, 93, 4, they were there. And subsequently, is because of the law teachers. Some law teachers complain to the Bar Council how they are practicing, and then it has come out, and gradually it has become, it's a full-time job. Legal profession as a full-time job. If you continue as a part-time, suppose adjunct faculty or part-time teacher or visiting faculty, there's no problem in practicing. But I personally feel, with all due respect to all the teachers, the moment, so you encounter, we all encounter, there are good teachers, there are very good teachers, and they are only a reasonable teacher. I'll not say bad, but they are equally, so all are good, but you can do in the different categories of the good. So they may go to the court and not come to the class. You will find a large number of so they will get a huge salary from the university system, and particularly in the central university and state university. Once you become in the part of the central university and state university, you hardly get you'll see your teachers are not coming into the class. That kind of danger is there. We are not like United States, where sometimes you go to the court, sometimes you come to the university is there. And teaching requires full-time involvement. I believe that what students like, what personally I feel in a number of years, availability of teacher, accessibility of teacher, and willing. So availability, accessibility is very important, and timely discipline on the teacher also. Teacher enters on the time in the class, go on the time. If these three are there, students like, and students also share something they want, if they can meet your teachers anytime. So it's better teacher to let them continue to confine to the teaching. Don't send them to the court. Otherwise, ultimately, who will going to be affected? You are going to be affected. Yeah, so it's better, I feel, if somebody feels he is good, he can practice, he always welcome to go to the practice. Anytime you can leave teaching and join the legal profession. Like P.P. Rao, I'll give an example. P.P. Rao, P.P. Rao was full appointed teacher of the Delhi University. And he had some problem in that particular time in the Dean P.K. Tripathi, assistant professor. So he was a constitutional law teacher. He was appointed, he worked for 6 years. And then all of a sudden some problem, and then he left the job. He left the job, and other teachers, they said, what you are doing, Delhi University is good, you name, but no, I'll practice. I'll see that, I'll try my luck. And P.P. Rao become a good lawyer, very eminent lawyer, a teacher also. So there are some people took risk there, and they have excelled in their legal profession also.
Thank you so much, sir, for that answer. We have Subhajit Chaudhary with us. He would like to ask a question to you.
Good evening, sir.
Good evening, Subhajit.
So my question is that the imposition of lockdown has caused economic hardships, disproportionate economic hardships on the poorer section of the society. So much so that the daily wage laborers have been pushed to the brink of destitution. So what I wanted to ask is that in such a situation where through lockdown the government is trying to achieve the individual's right to health, but sir, under Article 21 there is also the concept of right to earn their livelihood. So in that situation, sir, these two rights under Article 21 are at loggerheads with each other. So how does this dichotomy solve itself in this situation, sir?
Right to livelihood means like working as right to work in that particular context. So that is you interpreted Article 21. It seems like livelihood. You have to work. That in that context, your interpretation, you can't depend on the dole of the state or support of the state. That is the way interpreting. Could you repeat again your question?
Sir, I was mentioning that even if suppose the daily wage laborer wants to work, go out there and work, but sir, it's not possible in the current situation, wherein the state has imposed a lockdown, and even if they want to achieve that right, they won't be able to. So, sir, I mean, I just feel that there's a situation where both these rights are at loggerheads with either.
Yeah, I got it. So right to life includes the right to livelihood, and when the state stops, you don't go out. You are locked down, and their livelihood depends upon the working every day. Like they are not then survive. That is there. So when the state has stopped, so right to life is actually affected directly. So state has a responsibility. What government of India, on Delhi government, these are rhetoric, I believe, and you also may agree with that. They're actually the pinch or effect or impact of the lockdown has been strongly felt by the poor people, working classes, unorganized people working in the unorganized sectors. In the newspaper, we see that how much crores of crore money is distributed, food is the ration is given, all these things are there. But in reality, there is a huge gap. In fact, it has increased corruption. Distribution is corruption. Money has not gone on the right hand. These are the huge challenges. So this is also an opportunity. Lockdown is necessary. So second time, there is a mild form of lockdown was there in Delhi and other places where people were allowed to work. The construction side were there. First time it was huge, and that has affected large number of family. And even in the second occasion, it was limited work. It's not a huge. So large number of workers were rendered jobless. No doubt about that. There was no support from the state. There was no support from any other organization. So how some survive, some are still facing problem. How to overcome? How to ensure that these people in this kind of situation are live with dignity, live with their minimum adequate standard of life, their livelihood, because that what I say, that violates their Article 21 of the Constitution. So state has a larger responsibility, and state has to ensure the distribution mechanism, public distribution system and other mechanism effective. I hope, and that can be achieved if state start trusting the other stakeholders. Other stakeholders means civil society, non-governmental organization, other. So if you work in the collaboration with the working together, then some extent, and even the university students, college students, they are willing. Many students of your university also, they help. They are willing to. They wherever they are rendering the services. So we have to tap. The system has to evolve some kind of mechanism to mitigate their sufferings. So mitigating their suffering is very important, which has not happened, and thus, as you said, that has violated their livelihood and Article 21 of the Constitution.
Thank you so much, sir.
Thank you, sir.
Thank you.
Next question. Next question is sent to us by Krishna Tiwari. How has the right to health evolved in the light of COVID-19 pandemic, keeping in mind the various unforeseen circumstances we have faced over the last 2 years?
Aditi, go slow and repeat again.
Sure, sir. How has the right to health evolved in the light of COVID-19 pandemic, keeping in mind the various unforeseen circumstances we have faced over the last 2 years?
Evolution of right to health, how in the new dimension is, of course, I'm also part of that evolution process last 2 years. So I see that scholars have also evolved in the right to. So a new perspective has come in all dimensions. If I see for last 2 years, yeah, some problem is there. So if I see that what last 2 years, right to health, I discussed with you also. I said a new dimension has come to the right to health by all stakeholders. Right to health as an independent right. I started recognizing right to health as a social human rights. When we progressive realization, we talked in the beginning of the progressive realization. We have seen that resources, maximum available resources becomes a important factors in the implementation of the right to health. But in current crisis, which we are undergoing for last 2 years, it has posed a different kind of challenges, which were missing in the ordinary time. It was not there in 2019, 2018, 2017 or 16, because if you were sick, you took either borrowed money, or if you have money, you got the treatment admitted in the hospital, private and secondary. But we see number of things are coming. Now we have, even if institution, oxygen is becoming a big issue in the second time. Oxygen we never considered in the hospital. Bed become insufficient number of bed. Admission in the hospital has become big. Then also the knowledge, vaccine has become how to treat, how to prevent, how to move further. So number of areas, so science areas is important. Number of hospitals become very important. Necessary infrastructure become very important. Oxygen, which we never considered, is there. And oximeter we never consider as a lifeline attack. Oximeter you have to put in your finger. I had no idea. Many times I went to the hospital, they put the oximeter in my hand. So I said, kya ho raha hai? Always think blood pressure ke liye, just they put in your hand, then that's fine. But oximeter, and then you lived with the oximeter for 14 days every 94. So I had no idea that minimum 100 level, 95, 96 should be there, your oxygen level in your. So those are the developments which we have also been informed first time, and some way. Technology also, internet also is there. So right to health, particularly last 2 years, we have seen a huge push by the pharmaceutical sectors, governmental sectors, and private sectors, and even on the academic sectors. So there is a push so huge development has taken, and I am sure that this will, once this crisis is stabilized, it reaches a particular level, after stabilization, things will improve hugely. We will see a complete change and a better health facilities with better all necessary equipment and everything, not in the big cities, but also in the rural areas. We'll see some kind of development. So this will become a part of political slogan, right to health, for last 2 elections, right to development. Now onwards, right to health will also become, it will acquire a new space in the political discourse also in coming days. So I see 2 years, any suffering, ultimately it gives something to learn. If emergency was not there, we would have not landmark human rights judgment. So if landmark judgment is there in the human rights is actually post 1977 onwards. So we see this crisis will bring some positive note also and evaluation. And as you said, I totally agree. The evaluation of right to health has taken a huge step has taken in this by all stakeholders.
But sir, Shreya would like to ask a question to you now.
Oh, thank you, Aditi. So, sir, as you have explained, accessibility is an intrinsic part of right to health. So what is your take on the door-to-door vaccination policy? And do you think now is the time to bring such policy at a pan-India level?
That will be good idea, door to door, like polio vaccination started with initially in a hospital, but because polio is a different kind of, it requires long exercise. We can't wait for so long, and gradually it shifted to the door to door. Like after 2000, door to door, if they come to know there is a 5-year-old children or below 5 year, you will always every Sunday somebody will knock your door. So when my son was young, even he got every Sunday we have gone to hospital to to administer him the polio drug. But later on also somebody visited your house, aapka ho gaya, you have taken, yes. So that is there. But polio is like, this is different. This pandemic, when door to door, it will be a limited framework. It will not be in a huge, because the vaccine cannot wait for the 3 years or 5 years time or something, or future generation to be administered. It has to take only the present generation. So polio administration is the future generation also is there. So the crisis is at the time the present generation is there. Door to door is a good idea and it can work. I think so. But number of vaccine is not available. I believe that is the problem which we are facing. If more companies are coming, but door to door has to be free. Generally, door to door, if you say, private hospitals they are coming to the different societies. They are camping there. The private hospitals, what they are doing, or resident welfare association of all the private societies or cooperative society, they are asking hospital people to visit, and by that time people register and they administer it. So in the visit to the society is taking place, but everything is paid. You register, you pay the money. And what I understand that your concern is the door to door free vaccination has to be encouraged. That is not a paid vaccination, door to door free vaccination to be encouraged. I feel we managed to vaccinate everyone by end of December or by March, and then government may enter in the second phase or third phase where cases are less, few people have not been administered. That kind of things or facilities can be available. That is possible also. But it's we don't have sufficient number of vaccine. You have to search everywhere where to go and get it there. That problem is continuing.
Thank you, sir.
Thank you.
Thank you, sir. Shreya is asking, public health is currently a state subject. In light of the pandemic, it's often said that it should be placed in the concurrent list instead. Do you think centralization of public health is a good thing?
At least this kind of situation, and the central government is playing very important role, no doubt about that. So state is also blaming. They are not saying, they are saying the center is not helping, because there are certain situations where we should not enter into the list, neither the central government or the state government. This is a situation where we all have to work together. If a state like, if I say, or any Rajasthan or Bihar or Jharkhand or Madhya Pradesh, they don't have sufficient resources for the vaccine or sufficient fund. The central government has a greater responsibility. This is the extraordinary situation, which can be used in an emergency situation. So in that situation, of course, as you suggested, list, I said there is a entry list, entry 29 on the list, list 3, entry 29 is there some way infectious disease where central government has some role to play. We have National Health Policy 2017 also there. So central government has a very important allocation of fund is there. Even if it can be put more clearly if it helps the central government it can be added in the entry 3. There's no harm. Let it be the entry 2 also, and more clearly in some situation more elaborate, because 29 is not in much clear. It has to, there's no harm in there. If central wants to deal, center wants to play upper hand in such kind of situation, because center has to play, that can be done. It may take many years, but center has to, without going in such a crisis, even a subject which exclusively fails under the state domain, if a state is not in a position, central government and other state government has a responsibility to see the people, their rights. So our rights are not confined to the state of Bihar, state of Jharkhand. It's a state of, so it's not, so our rights is put like, no, it's within the territory, and even the other states have responsibility to protect our rights.
We have Krishna with us. He would like to ask a question to you.
Yes, Krishna.
Good evening, sir. So, as you mentioned, the observation of court on public health centers, the PHCs, in the pandemic, there were various reports which showed that the CHCs, the community health centers, and the PHCs in the rural parts of the country were mostly dysfunctional, or they were not working. So, doesn't this violate the right to health of those in the rural areas? And what should be done to change the state of affairs, as in the immediate capacity, in order to be
on the television, as you just mentioned, this small community health center in the village and block level, and those community health center is converted in the cow shed. Cows are like, there, and then cow dung are there and very dirty, and some are broken. That we have seen in there. That is real also. I'll not say one. It's a real condition. So whom to blame? The first thing. So state created there, appointed a doctor and one nurse to go there. Neither nurse never visited that particular remote places, nor doctor. So some way we have to also share some responsibility and blame. We feel that, doctors are not going into the remote places. If in a district town, you are there in a district town or district city, so everybody wants to live in the city, but not go to the village. So some strict mechanism has to be there. One. Second, to make it functional, some necessary internship, some necessary months student have to spend in the village. Like, as you are willing to go anywhere for your internship. Similarly, a student of the first year or third year MBBS has to spend 6 months in there. If they stay in the 6 months, always that village center, by third year, they have a sufficient knowledge to address medical emergency. I'll not say admission for the operation, but medical emergency, some kind of administering syringe or other things is possible. So some changes are required to make this functional, where involvement of their more number of medical colleges has to be created. We don't have sufficient number of medical colleges, also an issue in the country. Otherwise, after when you have a job, you are doctor in a city, you have been appointed, you don't go, and once in a while you go, you spend some time, you come back and encourage people go for the practice, private practice. So what we see, we are witnessing, private practices are flourishing, not in the big city, even in the small city. In big city, the culture has changed. So people of city, what we see that private hospitals, now doctors are going, the private practice has been very limited. More they become part of the private big hospitals where they get a good salary. But a small city is this private, small, one doctor is there, one compounder, we see that flourishing. So some way involvement of the number of the medical hospitals have to be increased, like MBBS, colleges have to be increased in each district, or at least on the 3 to 5 districts, one medical college should be there. The second, students should spend some time as an intern in the village. So that particular time they will not have a problem. When they have no job, they will be happy to go. Spend 6 months in the village. And third, try to see somebody are selected from the nearby to run that particular hospital. And panchayat has to work panchayat and municipalities have to also play very important role. They should not also become part of the corruption engine.
But sir, Digressing a little from the topic, I would like to ask you a question. How do human rights law, refugee law, and humanitarian law interact with the provision of health assistance?
So in all instruments, particularly even in the, if I say, uh, all human rights instruments, you have CEDAW also talks about the human health. CRC also talks about this human health. Convention Against Torture also talks about the health of the detained persons in the custody. So health is the common, like, it's like potato everywhere. So health is there in all human rights instruments. So there's no problem. You can look into. Refugees also health, health of refugees. Refugees have the rights. Once you, so if a refugee convention you look into, once a refugee convention, if I let's say you 1951 convention on the refugees, so once you admit a refugees, a state can make a discrimination on certain part, that may be right to movement, right to employment, but rest of the rights are there. So like the constitutional right to health are available to the refugees also. Forget about the convention. So like Indian constitution right to health is available to Rohingya refugees. The government of India cannot say, you are Rohingya, you are living here. You may ask documents. That also you can look into later on. So they are entitled for the through the human rights constitutional, and even if you are party of the 1951 convention, which also talks about the right to health, right to education, right to work, right to intellectual property rights. So everything in the convention also there. Basically, convention, why India is not party or many countries, because it speaks about the economic, social, and cultural rights of the refugees. Once you identify, then these rights become prominent. Once you admit them as a refugees officially, then the other rights become operational. First right, you have to take care of right to food for everyone, right to life. So Supreme Court has also said. So Refugee Convention also addresses all the Geneva Convention, international humanitarian law actually started with uh, ameliorating the condition of sick and wounded. It's largely for the medical treatment of the persons who are soldiers wounded in the battlefield. So protection and care, evaluation of the international humanitarian law, it's basically the care for the those who injured in the battlefield. If you go back to the history of the international, modern history of the international humanitarian law, and particularly Henry Daunt, when he witnessed the suffering in the Battle of Sulphur, say Memory of Sulphur, there is a book. You see, there he says when he saw that people, dead bodies scattered everywhere, so he became so concerned that nobody is thinking. So international humanitarian law focuses on the protection and care of those who injured in the battlefield. So entire Geneva Convention is, whether it's a first Geneva Convention, second Geneva Convention, and third Convention. So prisoners of war, if they are admitted, their health is also important. So health is in all human rights instruments prominently figured and there. Even if it is not there, wherever they are, people are there, it's the obligation of the state through the local laws, constitutional laws, and human rights law available to them.
Thank you so much, sir, for that answer. Now, Tanish would like to ask a question to you.
Wanted to ask you that if healthcare is a human right during pandemics, is the state under any kind of obligation to provide a compensation for every fatality caused due to insufficient provision of healthcare by the state?
Resources play very important role. And even if I take you to the, I'm just missing the name of the case, South African court, because we look into a transformative constitution, implementation of economic, social, and cultural rights. We go to the South African constitution, particularly after 1994, is very progressive. And Article 27, paragraph 3, there are some similar situations where South African cases court also dealt with. They said, but they said, you can't put, that is related, one case that is related with the treatment, continuous treatment of a person who required dialysis. So court has, so they said, hospital has denied, there's no like facilities. So court has said, though right to health is a human rights, but resources, state can also deny, because it's not possible to administer completely treatment for everyone. Otherwise, everybody is very difficult. So some ground is there, like, and there is a difference. Right, the moment right to health, you change the right to health care, it dilutes. right to health as a human rights. What is important, we have to recognize right to health is human right. The moment healthcare, if state has failed healthcare in providing healthcare, or because of this pandemic failure, so compensation, like whether the victim has a right to seek compensation on ground of denial of the health facilities. If that happens, that of course they can go to the court, and how court looks. So I can't give a final or end judgment on that particular part. There may be possibility, but it may not be. It will be difficult for court also to say, you grant the compensation to the, because you fail to take care of that particular person, A or B or C. So that will be difficult, because it also, from the very beginning we discussed, it's a progressive realization resources. And I feel it there is no prohibition as such, people going or invoking Article 32 of the Constitution. But when it comes to the awarding compensation, the way court has done in the release of detainees, or keeping them on the, for the duly for longer period, like Husanara Khatun, Dudul Shah, and Saheli, series of cases where Nilavati Bera torture cases, court has developed the compensatory jurisprudence. But whether in the denial of the health care, if it can be established strongly, death has taken place because of denial, it may work out, it may not work out, but I feel it's difficult, because it's a huge and it's a challenge.
Thank you so much, sir. Krishna is asking, sir, what steps should be taken by the government to ensure right to health for health workers? We have recently witnessed violence against doctors and health workers in this pandemic. What steps the government should take to tackle this? Is there a need for a statute for the same?
Government, though, definitely they are arrested. Those who have an IPC and various sections are invoked. So persons who pay, but these are very emotional issues. Like we have to restrain, we have to be civilized, we have to handle. So like if something goes wrong, delay in admission in hospital, people it's a very emotional situation. So even the person who gets entangled in this kind of situation, whether it's from the patient side or other side, his logical thinking or reasonable thinking stops. He starts become like very agitated person. Whether it's possible to have sufficient number of police, everybody has to reduce the number. Only the patient has to be handed over to the hospital authorities 1 kilometer away from the hospital. They are not allowed to enter. These are the in Western societies that are there. Patients are not allowed. You phone the some ambulance will come take, and you are not supposed to go to the hospital. So some information is there. Here one person is injured, 30 friends are there jamming all the time. So it's become there are systems which it works, and in our system it doesn't work. If we feel we don't have sufficient number of police, we don't have sufficient number of enforcement persons. Privately they are managing, hospitals are keeping their own people, own security guards to handle this. But both parties have to be, the persons who are in approaching hospital for treatment has to understand the challenges which healthcare staffs are facing. And nobody wants, including doctor, the patient should die. But he or she also works 24/7. There are a lot of challenges are there, and they are unable to stand the expectation which other party has. The moment I go, immediately I should be admitted, and doctors should administer everything. That is not possible, and particularly in the extraordinary situation. So many people, they stayed. Later on they realized, and even the societies, they started administering oxygen also in the home. So one has to avoid what happened in the Assam, the young doctor who was brutally beaten by the family members. Still it's a big issue. Of course, these are people have been arrested. They are in the they will face. But we don't have sufficient number of guard or something. So this will continue, Krishna. This will not stop.
Thank you so much, sir. We have our last question sent to us by Toshita Jha. Sir, you have relied on ICE SCR and the general comments on the same to highlight the accessibility and universality of rights. But practically, with provisions like progressive realizations, especially, the states can easily derogate from its obligations. Moreover, derogation from such conventions is allowed in emergencies. So, how do you think can compliance with obligations under such international law conventions can be ensured?
If you read in the, you rightly pointed out that focus is the general comment number 14, which talks about the elements as you identified. But it also, you have to read the general comment in the context of the Article 2 of the obligations. Article 2 of the International Covenant on Economic, Social and Cultural Rights. So what Article 2 speaks about? It talks about the, state can, it talks about the, just a second, I'll read. Each state party to the present covenant undertakes to take steps individually. So first you take individually and through international assistance and cooperation. Through international assistance and cooperation. What is there? So under the international instruments also clearly state. So they have also realized what we are asking a poor state like in Sudan, Somalia and other countries to, even if they are party, they will not be able to implement. So convention say कि maximum resources, maximum available resources, what it is been interpreted, available resources at the domestic level and international also, maximum available resources. So what you have to utilize your resources in a manner to provide. It should not be unlimited or open-ended. So the limitations have been recognized. Limitation has been recognized under the convention itself. Under the Constitution, Article 37 also, it says very fundamental in governance. If you look into the Article 37 of the Indian, but when it comes to this, non-justiciable. So somewhere resources become very concerned in all the domestic level or international level. So, but states have to progress. So you have a framework. Framework, what it says, what is the availability, what is accessibility, what is acceptability and quality. You have to gradually achieve. It's not non-compliance. If government is not today having all these facilities, it's not will consider it's a non-compliance. We say it's a failure of the government of India and it's failure of the international organization and international assistance also. And I'll take you one important, which I did not mention. This is another important crisis or serious crisis which erupted in 2013 and 14 in Ethiopia and a number of the African countries. Ebola crisis. Ebola crisis, if you remember. And that is the first time, like you can explore further, the Security Council of the United Nations adopted a resolution, Security Council Resolution 2177. The first time in the history that is related with the right to health, related with. So they said that the crisis which is going in, Ebola crisis, will disturb international peace and security. So health crisis which African nations are facing, it has because this resolution was adopted under the chapter 7 of the United Nations Charter. As you know, when you chapter 7 of the United Nations Charter, it talks about the enforcement measures, implementation. So it's very huge. It applies only in case of the crisis or conflict, like first Gulf War, or chapter 7 is not invoked in ordinary. So unfortunately they did not discuss about right to health as a human right. They talked about the right to health and the international peace and security context. So look, many people, not a single time they used human rights on that Security Council resolution, in Security Council Resolution 2177. So non-compliance is largely because of the unavailability of the resources are not available. So state has to make a continuous effort. What is it intend? Even availability is a framework. What you have to achieve, this framework you have to achieve. These elements you have to achieve. But you have to work towards that. So what I'm saying, if you compare with the Indian court judgments 1996 onwards, what the court had said, It's a constitutional obligation. You forget about the international law. You come to the Paschim Bang Khet Mazdoor, court has clearly stated, if state says ki shy away from fulfilling this obligation, there is no justification because it's a constitutional obligation. So state has to do. So it may take some time. We are not saying in system, but state. So honest interpretation or honest analysis will say state has not taken it so seriously when it comes to the health, and in fact state has handed over this task to the private medical facilities. So they have handed over, they are giving hospital spaces to the private companies, Apollo, Max and name, and you have Amri in Calcutta, Columbia Hospital. So they are the state creation, state prime land has been given and state is giving, okay, we will not create, but let the private player people pay and get the treatment. So that is not justified. You continue private, but same times you have to have equal number of the health, public health centers.
Thank you so much, sir, for the question answer session. It was indeed an honor for each one of us to learn something from you on the topic status of right to health in India and globe among pandemic. Thank you for agreeing to have a session with us. I would request Sayam Jha to deliver vote of thanks.
Dear sir, on behalf of the informal discussion group, I, Sayam Jha, would like to take this opportunity to extend my sincere and heartfelt gratitude to you. We are extremely honored that you graced us with your presence today. It is a privilege for us to have interacted with you, and I'm certain each and every one of us has something to take back and ponder about from this session. I would like to thank you for sharing your knowledge and enlightening us with the nuanced spectrum of right to health and its global implications. I would like to extend my appreciation to all the members of the IDG who worked tirelessly to make this session a success. I would also like to extend my appreciation to the faculty members and GB members for their participation and bringing up insightful and intriguing questions throughout the session. Thank you so much.
So really, I thoroughly enjoyed, and it was a great honor for me personally when I got an invitation from all of you, and particularly Aditi and Tanis regarding this. I thought about it, and it's a great pleasure when I interact with particularly our own student and UJS student. So it was very interesting for me. And what I want to add, those who are here, so and it applies to all of you, all the students of the university, and particularly with all of you. If any way I can help, or any way writing a recommendation letter, internship, or paper publication, whatever way, limited way I can contribute in shaping your legal journey during your college time and even after your college time, it never ends. So our relationship, though on the online, so it will never end till we are here. So during the college time, even after college, 5, 6 years or 7 years, whenever you want something, you just say, and I'll be happy to, whatever possible, I'll happy to do that. So you take it from me, and I'm just saying that you 11 or you all members and other students also is open for all of you. So thank you very much.
Thank you so much, sir.
Thank you.